Hi guys, welcome to today's Legal 101. Being a Tuesday, it's on tax law. So, what we're talking about today is tax appeals timelines, particularly when one wants to appeal a decision made by the Tax Appeals Tribunal before the High Court. Now, in matters tax, time is very crucial because it is understood that both taxpayer and KRA have to make informed decisions. Now, when you look at section 32, subsection 1, and when you look at rules 3 and 4 of the Tax Appeals Tribunal Appeals to the High Court Rules of 2015, you will note that it is provided that if one wants to lodge an appeal to the High Court against a decision emanating from the Tax Appeals Tribunal, they have 30 days to lodge that appeal. But if you're unable to lodge it in good time, you may seek an extension of time from the High Court. Now, in seeking this extension, you must explain to the High Court the reason for the delay, giving proof as appropriate. Now, the rules envision the following reasons. Maybe you are absent from Kenya, maybe you are sick, or you have other reasonable cause for the delay. For example, now we have floods. If for whatever reasons the floods have caused you not to lodge an appeal within the 30 days, explain it to court. Sometimes you're unable to obtain a copy of the judgment in good time, and so you're not able to formulate your grounds of appeal well. That is a good reason you can explain it to court, but you must also be seen to have applied for that judgment and made numerous follow-ups. Previously, myself, before a different forum, I have explained that the reason for failing to abide by timelines was because the time ran through the Christmas period, and I explained what my client had to go through during that period that could not enable them to lodge an appeal or lodge their responses. And while some courts may not be very receptive to this reason, because sometimes courts actually sit 27th December, 28th December. They'll be like, when you go happy, that you might be able to explain all the personnel was away from the office and the court might be lenient enough. But sometimes this has to be weighed with the number of days you actually were late by. For example, if you have 30 days and you are late by another 30 days or 45 days, then that delay is not inordinate. But if you are late by 3 months, 4 months, 6 months, that has to be weighed vis-a-vis your reason for the lateness. And then typically sometimes you may want to blame your advocate for causing a delay to your matter, and it might be seen as unprofessional, and that is subject to determination by the relevant professional body in charge of investigating unprofessional conduct or professional misconduct. But in that moment when you're explaining it to the particular court that you are before, it might not be enough to say I failed to put in my appeal because so and so, who was the professional in this matter, did not act as they should have, or I did not pay them and so they did not appear in court. Personally, I will not do anything for you if you have not paid me, especially if you had an agreement on the payment. I will deem it a discussion on your goals and dreams. I think you have seen that meme. Because honestly, why do you want me to work for you without payment? However, there are instances where that is taken as being unprofessional. Now, an application seeking extension of time is not an application for stay. If you have a judgment that has upheld the decision by the taxman and you're supposed to pay some certain amounts, if you don't actually seek stay of that decision, then KRA will proceed to seek attachment of your property or to require you to pay that amount. So just because you have sought extension of time with an intention to appeal does not mean that KRA is stopped from going after what they believe is owed to them, and actually what is owed to them as per the existing court order. Lastly, and I always say this, goodwill, good manners during any court proceedings will take you a very long way. Courts are very likely to give you orders where the orders are discretionary to them if you are able to demonstrate, or if you, in your dealings with them, you're very respectful, you abide by timelines, you're not combative even when you do not have to be. If it's virtual court, you attend in time. If your matter is called out, you respond quickly. If as a witness you're a very you're eager to explain to the court what the issue is instead of confusing the court to convolute issues. Such things, just good manners, can take you a very long way. So that marks the end of today's Legal 101. I hope you have learned something. As a taxpayer in this country, it is in your best interest to know about these timelines. Like I said, you need to make informed decisions, KRA as well. See you tomorrow for tomorrow's Legal 101. Feel free to ask questions in the DMs, in the comment section. It's okay. See you tomorrow. Bye.